Mr. Singh, one request. I'll tell you why we were trying to put a little time limit now. With all the hard work which has been done by your side, I think, we have reached a point of mental saturation, not fatigue. But mental saturation where we are now, there are questions to be posed to the other side and answers to be required from the other side.
Yeah.
So in that sense, conscious as we are that if we are putting an end to your argument a little earlier, on the reorganization, we'll bear that in mind so that when they respond and it comes to the rejoinder, we'll give you a little more time in the rejoinder because then you will have to really deal with what their defense is.
Yeah.
Because broadly, reorganization was argued before you also, though you've put it in a different way. We have seen the provisions now. We would now like to be in a situation where we conclude this part and we sort of, we have questions to the other, to be posed to the other side. We have to demand answers from them. And we're now at a point of the matter where, you want now to move on. That's the only thing. I mean, it shouldn't be misconstrued why are we sort of curbing arguments.
No, I'm conscious of the anxiety of the court.
6, 7 counsel lifetime. It is such a matter which has such no ramifications. So
yes.
Just some kindness from your lordship.
Yes.
So
yes, Mr. Singh.
I'll just summarize the point on the union territory aspect. I have, in fact, in my written submission, I've got a detailed note on it. I'll just flag that to your lordship. Let me just summarize it in 3 or 4 sentences.
Yes.
That's all. So basically the point is this, that the history of Articles 3 and 4 emanating from the 1919 and 1935 Government of India Acts.
Just one second, sir. The history of Articles 3 and 4 emanating from the
1919 and 1935 Government of India Acts shows that the powers to alter boundaries, change names, etc. was always used to increase self-representation and democratic self-government.
Under
there
Article
was no case of retrogression.
Was used to
increase democratic self-government and self-representation, and there was no case of retrogression. Secondly, my lords,
just one second. Yes.
These powers were always exercised after due democratic consultation with the people of the concerned region, state, or territory. And this, your lordship will find in my written submissions. My written submissions were that PDF 445 of the...
We won't say with the people of the territory, we'll say with the legislative representatives of the territory.
People of the territory through their representatives, which is why I showed your lordships the section 15, which is why I showed your lordships the footnote to section 15, the committee report which led to section 15 of the 1919 Act. Lordships recall that the committee report and what they said about the consultation. Similarly, the 1935 Act, and then, my lords, and in my written submission, which is that these points are made out. I'm just summarizing it. At page 445 of the combined written submissions is my written submission, PDF 445. From pages 464 to 472, I deal with this history and progression of union territories. 464 to 472. I'm not even taking your lordships through it. I'm just identifying it for your lordship. In particularly, my lords, paras 41 to 43, a note may be made of this. I've set out a chart of how various territories changed from Part C state to union territory, Part C state to union territory to full statehood, etc., etc. And that's why I was, the way I would sum it up is that when your lordships see Schedule 1 to the Constitution and the section on union territories, my lords will find that today there are only 6. I mean, take away Jammu and Kashmir, because even Dadra and Nagar Haveli and Daman and Diu have been merged into one in 2020. They've been merged into, they've been made into one unit. Even though because there are 4 small parts, 800 kilometers this side, 400 kilometers that side, etc., etc. Because between Daman and Diu, it's an 800 kilometer driving distance. I mean, not flying, but if you drive down the down the run of Kutch, etc. So, so these small non-viable territories have remained, which are not viable as states, have remained as union territories. None others. All have gone in one direction. So this your lordship will find in my note. I'll say no more about this. No, that's done. Now coming to the next point, lords, is that 3 and 4 have to be read. First of all, I said that 3 and 4 have to be read as part of part 1. Now, part 1 is very important because your lordships have been showed Article 1 and 2. Article 1 says India shall be a union of states. Article 1 was amended by the 7th Amendment when union territories came to be introduced. But Article 1.1 and 1.2 were not amended. Union territories were added in 1.3. Sorry, in 1.3b. So even while amending in the 7th Amendment, India, that is Bharat, shall be a union of states. The territory, the states and the territories thereof shall be as specified in the first schedule. These were not amended when union territories came into being in the 7th Amendment. What is added is 3. The territory of India shall comprise A, the territories of the states, B, the union territories specified in the first schedule, and C, such other territories. But the basic concept of India, that is Bharat shall be a union of states, was maintained. Article 2 was maintained as it is. Admission or establishment of new states. Parliament may, by law, admit into the union or establish new states on such terms and conditions as it thinks fit. Article 3 was not amended till the 18th Amendment, when those 2 explanations were inserted. Now the explanation has become the tail which is wagging the dog. And from that it is sought to be contended by the union that because the explanation says for certain portions the state shall include union territory, therefore any permutation and combination is now available to Parliament under Article 3. Now, keeping aside the fact that the two explanations were never extended to Jammu and Kashmir. The two explanations which were introduced by the 18th Amendment were never applied to Jammu and Kashmir.
Just one second.
I'll come back to
made
that,
that
keeping that aside for the moment. So this fiction that you can convert a state into a union territory was, by the Constitution of India, never applied to Jammu and Kashmir. But keeping that aside for a moment, because I'll come to that on that timeline issue. Now, please see the enormity of it if you accept this argument for a moment of converting states into union territories as a whole, and for the whole of the country, including Jammu and Kashmir, because we are saying that it's an integral part of India. Please see Article 294 and 295 may just be seen. These particular articles I want to show because my Lord, the Honorable Chief Justice wanted to know how were these provinces dealt with by the Constitution of India. So under 294, those properties of His Majesty's government, which were used for the dominion, became part of the union properties. Please see 294A. All property and assets which immediately before such commencement were vested in His Majesty for the purposes of the government of the Dominion of India, and all property and assets which immediately before such commencement were vested in His Majesty for the purpose of the government of each governor's province shall vest respectively in the union and the corresponding state. So properties which were for the Dominion vested in the Union of India, properties which were for a governor's state, which were being used for a governor's state, vested in the corresponding state. Punjab, Bombay state, Madras state, etc., etc. The properties pertaining to that state vested in the state by constitution. Similarly, all rights and liabilities, etc., again, respectively in B. Then 295, succession to properties, assets, and in other cases. Now, please see 2. Sub 2, I'm just taking a look. This is now dealing with the Indian state. Subject is aforesaid, the government of each state specified in Part B of the first schedule shall, as from the commencement of this constitution, be the successor of the government of the corresponding Indian state as regards all property and assets and all rights and liabilities and obligations that are arising out of any contract or otherwise, other than those referred to in clause 1.
Yes.
So those properties became the Part B states properties. Part C and Part D were not defined here because the union had control of them. The union had control of Part C and Part D, so they remained in a sort of a silo. Because what really happened is Part C and Part D and union territories are really a stepping stone. It's a silo kept as sort of a holding pen, so to speak, till you can get full statehood. The holding pen, the silo in which you're kept safe and secure under the benign umbrella of the Union of India. It's really for that. It was never intended.
And Mr. Singh, anyway, Mr.
Now,
Nafde,
I'll just make good this point.
Mr. Nafde, in the concluding part of his submissions, has given us a whole list of what the impact on the constitutional structure is. And we have made note of that. 1, he said Ladakh has no representation in the Rajya Sabha. 2, Rajya Sabha, all of the 4 seats go to J&K. 3, Lok Sabha, Article 81C, all UTs can have a maximum of 20 seats. Article 81(2), other states' seats depend on population. J&K has no proportional representation in the Lok Sabha. Presidential election, Article 54 and 55. Yes. J&K, no MLA for presidential election. The reorganization of Act of 2019 gives the same rights as Puducherry. 279A, no representation on the GST Council, and High Court judges, no views of the CMRT.
I'll just add a few more. Now I won't take your lordship to the sections. I wanted to show this section just to show how property and rights devolved. Now I'll just mention a few words. Under Article 266 provides for the consolidated fund of the union and a separate consolidated fund of the states. 261 and 2. 283(2) provides for the custody of the consolidated fund of the state and the manner of withdrawal from that custody. 289 exempts the property and income of a state from union taxation. 283 162. Now, this is very important. 162 says, subject to the provisions of this constitution, the executive powers of the state shall vest in the state in respect of list 2 and list 3. List 3 only if Parliament makes a specific provision by a law to exercise executive powers in respect of some particular provision of list 3, executive powers now I'm talking about, only then to that extent the state will yield executive powers to the union. Otherwise, all executive powers in the state on subjects of list 2 and list 3 are exercised by the state. And this is not subject to a law made by parliament. This is subject to the provisions of this constitution. The reason it is subject is like 256, 257 are a qualifier on 162. 256, 257 is where the union, for purposes of defense, etc., can encroach to some extent on the powers of the state. 73 is the concomitant executive powers of the union. 73 has a, please just see that, 73 has a specific provision which says the union shall not exercise any of the powers of the state. 73, subject to the provisions of this constitution, again, not by law, the executive power of the union shall extend to matters with respect to which parliament has the power to make laws and to the exercise of such rights, authority and jurisdiction.
Proviso, the proviso.
Now, proviso, provided that the executive power referred to in subclause A shall not, save as expressly provided in this constitution or in any law made by parliament, extend in any state to matters with respect to which the legislature of the state has also powers to make law.
The proviso to 73 and the proviso to 162 are mirror images.
Mirror images, mirror images.
Because
So,
the executive power of the state also extends to laws, to concurrent field subjects,
that's right.
and including any law made by parliament in the concurrent list, unless parliament expressly reserves the power to the union government.
That's right. That's right. Absolutely right. Then verse 293 further clarifies that the executive power of the state extends to domestic borrowings against the consolidated fund of the state. So there's a specific constitutional power of that. 298 extends the executive power of the state to carrying on trade or business, acquiring properties, etc.
All right, Mr. Singh.
And then 246 and the lists.
Yes.
Now by a simple expedient of a simple ordinary majority under Article 3, all these constitutional rights, many of which are directly part of the basic structure of the Constitution, are wiped out. So, look, the theory is...
Point is taken, Mr. Singh.
No, this has been dealt with by your lordship, fortunately, and I want to just place that. Following, if your lordships are kind enough just to see the judgment of a constitutional bench in Shankari. Where's that one? It's all displayed. So, if my lords are kind enough to take up Shankari Prasad, I'd ask the learned court master to keep it ready. It's on the screen. This is AR 1951 SC 458, and His Lordship Justice Patanjali Shastri, speaking for the bench, spoke of harmonious interpretation of the different modes of amendment under the Constitution.
Para?
If your Lordships come to para 6, on the first point it was submitted, and then overleaf, let's come to the last about 8 lines of para 6, various methods of constitutional amendment. Do your Lordships find that? Various methods of constitutional amendment have been adopted in written constitutions, such as by referendum, by a special convention, by legislation under a special procedure, and so on. But which of these methods the framers of the Indian Constitution have adopted must be ascertained from the relevant provisions of the Constitution itself, without any leaning based on a priori grounds or the analogy of other constitutions in favor of one method in preference to another. We accordingly turn to the provisions dealing with constitutional amendments. Now, the Constitution provides for 3 classes of amendments of its provisions. First, those that can be effected by a bare majority, such as that required for the passing of any ordinary law. The amendments contemplated in Articles 4, 169 and 240 fall within this class, and they are specifically excluded from the purview of Article 368. Secondly, those that can be effected by a special majority as laid down in Article 368. All constitutional amendments other than those referred to above come within this category and must be effected by a majority of the total membership of each house, as well as by a majority of not less than 2/3 of the members of that house present and voting. And thirdly, those that require, in addition to the special majority above mentioned, ratification by resolutions passed by not less than 1/2 of the states specified in Part A and Part B of the first schedule, This class comprises amendments that seek to make any change in the provisions referred to in the proviso to Article 368. This is what my learned friend Mr. Nafde highlighted, some of those provisions which directly fall within A to E of the proviso. It will be seen that the power of effecting the first class of amendments is explicitly conferred on Parliament, that is to say the two houses of Parliament and the President. This would lead one to suppose, in the absence of a clear indication to the contrary, that the power of effecting the other two classes of amendments has also been conferred on the same body, Parliament, for the requirement of a different majority, which is merely procedural, can itself be no reason of entrusting the power to a different body and examine it. Because the argument here was being made that a constitutional amendment can't be made by Parliament, it has to go back to a constituent assembly. So that was a negative. Now, Milord, this was followed in Sajjan Singh. This Shankari dealt with the First Amendment, and Sajjan Singh dealt with the 17th Amendment, that is AR 1965 SC 845. And para 7, 8, please just see the first 4 lines of para 7, Sajjan Singh. In our opinion, my lord, have that? In our opinion, the two parts of Article 368 must, on a reasonable construction, be harmonized with each other in the sense that the scope and effect of either of them should not be allowed to be unduly reduced or enlarged. Then in para 8, Milords, about line 7 from the top, in other words, in construing both the parts of Article 368, the rule of harmonious construction requires that if the direct effect of the amendment of fundamental rights is to make a substantial inroad on the High Court's powers under Article 226, it would become necessary to consider whether the proviso would cover such a case or not. If the effect of the amendment made in the fundamental rights on the powers of the High Courts prescribed by 226 is indirect, incidental, or is otherwise of an insignificant order, it may be that the proviso will not apply. In other words, you have to harmonize these two provisions, and if it is substantially falling within, impinging on those A to E of the proviso, then you have to follow the greater. Then come to para 30, Milords, of this.
So we'll see that, Mr. Singh. This is well settled. We'll have a look at it.
Very well. I only want to point out para 30, Milords, because para 30 deals with Article 4 directly. So I would request your lordship, Milords. Para 30. Incidentally, we may also refer to the fact that the constitution makers had taken the precaution to indicate that some amendments should not be treated as amendments of the constitution for the purpose of Article 368. Take, for instance, Article 4.2, which deals with law made by virtue of Article 4.1. Article 4.2 provides that no such law shall be deemed to be an amendment of the constitution for the purposes of Article 368. Similarly, Article 169.3 provides that any law in respect of the amendment of the existing legislative apparatus by the abolition or creation of legislative councils in states shall not be deemed to be an amendment of the Constitution for the purposes of 368. In other words, laws falling within the purview of Articles 4.2 and 169.3 need not be passed subject to the restrictions imposed by Article 368, even though in effect they may amount to the amendment of the relevant provisions of the Constitution. So, they say that these provisions have to be read harmoniously, as in Shankari, and they are exempted. But the exemption can't mean that you completely efface if you are falling within 368, to efface, Milords, the provisions there. Now, as it happens, Milords, this is, if your lordship just goes very quickly, Milords, to the Constituent Assembly debates for a moment, I just want to show your lordship Dr. Ambedkar on this, his speech on this very same provision, and why this ascending power of amendment, and how it has to, each one has to apply only in their limited sphere. So if your lordship sees volume 8 of the documents, and at page 881, this is Dr. Ambedkar's speech, begins at the previous page 880, dealing with Article 304, the draft Article 304, which is 368. Now, para 4, Milords, on page 881. Now let me turn to the provision of our Constitution. What is it that we propose to do with regard to the amendment of our Constitution? We propose to divide the various articles of the Constitution into 3 categories. In one category, we have placed certain articles which would be open to amendment by Parliament by a simple majority. That fact, unfortunately, has not been noticed by reason of the fact that mention of this matter has not been made in Article 304, but in different other articles of the Constitution. Let me refer to some of them. Take, for instance, Articles 2 and 3, which deal with the states. So far as the creation of new states is concerned, or the reconstitution of existing states is concerned, this is a matter which can be done by Parliament by a simple majority. Similarly, take, for example, Article 148A, which deals with the upper chambers in the provinces. Parliament has been given perfect freedom to either abolish the upper chambers or to create new second chambers in provinces which do not now have them by a simple majority. Now take Article 213, which deals with the states in Part 2. With regard to the constitution of the states, the draft constitution also leaves the making of the constitution of states in Part 2 and their modification to Parliament.
Nothing much turns on this, really.
No, the harmonious reading, if your lordship.
That's well settled. Why do we have to read the speech for that?
I'm sorry, Milord?
We don't have to read the speech to have harmonious construction.
No, I'm only on this, what Justice Patanjali Shastri, the formulation that he made in Shankari, actually.
The three provisions, bare majority, two-thirds majority, and two-thirds majority with ratification. Those are the three separate provisions.
Just see page 82 for a moment. I'll just flag it. Your lordship may just flag it. The third para in 82, now what is it we do? And the next para below that, after the interjection by the president, yes, now we have no doubt put certain articles in a third category where for the purposes of amendment, the mechanism is somewhat different or double. It requires two-thirds majority plus
ratification.
I shall explain why we think that in case of certain articles, it is desirable to adopt this procedure. If members of the House who are interested in this matter are to examine the articles that have been put under the proviso, they will find that they refer not merely to the center, but to the relations between the center and the provinces. We cannot forget the fact that while we have in a large number of cases invaded provincial autonomy, we still intend and have as a matter of fact seen to it that the federal structure of the Constitution remains fundamentally unaltered. We have by our laws given certain rights to provinces and reserved certain rights to the center. We have distributed legislative authority, we have distributed executive authority, and we have distributed administrative authority. Obviously, to say that even those articles of the Constitution which pertain to the administrative, legislative, and other powers. Page 28283. It's very important because it specifically deals with 73 and 162, the articles which were 60 and 142. And it says that these cannot be changed. This ratio, this balance cannot be changed except by a special majority coupled with ratification by more than half the states. So that may be just noted. Now in Mangal Singh, this is reiterated, and I'll just give your lordship the pages now. Mangal Singh, your lordships will find at volume 6, PDF 386, para 6.
Yes.
And in State of Himachal Pradesh versus Union of India, volume 14, PDF 776.
Volume number?
14.
Volume 14, PDF 776, para 93. And this is very important, Lord, if I can just draw your lordship's attention to it. Specifically, the Supreme Court held, my lords, in this judgment, what is not permissible under, my lords, Article 3 and 4. If your lordships are kind enough just to turn to volume 14, page 776. Para 93, we find, my lord, have that? Volume 14, page 776, para 93. We find that under the provisions of Article 3 of the Constitution, Parliament has the power to form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, and alter the name of any state. But under Article 3, Parliament cannot take away the powers of the state executive or the state legislature in respect of matters enumerated in List 2 of the 7th schedule to the Constitution. This has been made clear in the speech of Dr. Ambedkar in the Constituent Assembly, quoted in paragraph 52 of the decision of this court in Kuldeep Nair versus Union of India. Relevant portion from the speech is quoted. The basic principle of federalism is that legislative and executive authority is partitioned between the center and the states, not by any law to be made by the center, but by the Constitution itself. This is what the Constitution does. The states under our Constitution are in no way dependent upon the center for their legislative or executive authority. The center and the states are co-equal in this matter. And then, my lords, your lordships have been shown Berubari in volume 13, page 492. Various paras, but my lord may just note the paras in Berubari, volume 13. It starts at page 492, paras 36, 38, 44, and especially 46 are very important. Then, my lords, R.C. Podial, etc., your lordships have been shown those. I won't. So,
just reeling of judgments.
I'm so sorry.
Just reeling of the judgments and giving para numbers. Doesn't it form a part of your synopsis? If it forms a part of your synopsis, we will give a consideration to it.
Well,
Otherwise, what's happening is you're depriving your other colleagues of a right to.
Because of in the context of that, this could only have been done under 368(2). That is the essence. Now, the last point, then I will close, is what the second point I had raised, but my lord, the Honorable Chief Justice wanted me to address on union territories to start with. So this is with regard to the timeline and how there was no power at all to table or enact this law at all in the manner in which it has been done. The reorganization. Please just take this timeline.
Exactly.
Parliament, how Parliament passes it, does it fall within?
No, if there was, the point here is if it is if CO 273 was not there and the Constitution of Jammu and Kashmir and the Constitution of India as applicable in Jammu and Kashmir was in force, this could not have been tabled at all.
Trying to say there was not inadequate debate, how the Parliament was conducted, this would be a difficult area to get. We understood the other propositions, but now to say,
no,
well, they did it in this much time.
No, if
done it not this much time, but this much time.
No, let me put, I'm sorry, it's my fault, I have not made the point clear. If Article 3 says, for instance, that it will not be introduced unless the president has done ABC, and it is apparent that the president has not done ABC. ABC gets done on the subsequent date. It's not there on that date. Rajya Sabha passes a bill which it is not competent to pass at all, not competent to even table or consider under the terms of the Constitution. Then that's all I'm trying to point out. Please just take a look at this. It's a very short, just a timeline of 5 entries of what happened on 5th and 6th. This is all from available in the, and I've given the PDF pages of each of the documents.
Just give us, what are the dates? You can tell us the dates. Just give us the dates.
Your Lordship,
We'll not be able to handle these sheets now. We've got everything in the soft form. I mean, these sheets will just fly around the place.
It just gives PDF pages. Very well.
This will be a part of our record.
Now, on 5th August 2019, CO 272 is issued by the President, which adds subclause D to clause 4 of Article 370. Substituting the Legislative Assembly.
Heading?
That might save your lordships a little time if I can just handle it.
It's not part of your synopsis. That's what I'm asking.
It must be part of your submissions, right?
It's part of your submission.
The written submission.
No, this timeline is not set out. This is all. It's in the COs and the what is in volume 3.
It's like a supplementary submission now being sought.
You don't want to, otherwise it will become
exactly what
impossible.
It's not a submission. I can take your lordships directly to the documents. It's not a.
So just tell us now quickly the dates so that we can wrap up now.
So when CO 272 is issued by the president. This merely adds a subclause D, which substitutes the legislative assembly for the constituent assembly of the state. On the same day, this is at volume 3, page 101.
To us, sir.
Let me close with that. We'll go through this.
Now, on the same day, the second entry, the Lok Sabha, on a reference from the president, this is the phraseology, passes a resolution to accept the J&K reorganization bill presented to it by the president for its views. Now, this is at volume 3, page 104. I'll tell your Lordship the importance of this.
We'll have a look at it. Yes.
Let me just make the point, Lord.
What's the point of doing this? See, you please tell us if we will not go beyond 4 o'clock. You ask your colleagues whether it's fair to them or not. That's all I'm saying.
May I just summarize the point in a few sentences?
1 hour was taken. We've given you 1 hour, 45 minutes. Still you feel something more has to be done.
50 minutes.
This is not fair, honestly.
If your Lordships have felt that I have repeated myself in any way or not
Everybody
been
has to ration
summarize
time.
it. We have
Everybody has to
summarized.
ration time, you know.
We have given you time. We have summarized it. At some stage, all good things must come to an end. The arguments must come to an end. Let us have the next council now to address this.
let me just make the point in 2 sentences, Milord.
Yeah.
The point here is that under the 2 explanations did not apply to Jammu and Kashmir until CO 273 got passed on the following day, and it was only recommended simultaneously along with the Rajya Sabha passing the Lok Sabha passing the J&K Reorganization Act. This is not permissible because until then, the Constitution of India as applicable to Jammu and Kashmir applied. The explanations were not there. Union territories were not in Article 3 as it applied to Jammu and Kashmir. So I'm saying that what was tabled and what was passed by the Rajya Sabha purportedly on 5th of August was something clearly contrary to Article 3 itself. So if they are founding their case on Article 3, I submit that is ultra virus. That's the point.
Thank you.
Thank you, Mr. Singh. Mr. Parekh? He'll walk down.
Because I'm very grateful that.
Thank you, Mr.
You
Will you be arguing?
I am conscious of, my lord, the time constraint. I must indicate, my lord, what I am going to argue. I am going to argue, my lord, one point with regard to the historical details, which has not come in, my lord, so far. The list of dates which was given, which is manifesto of 1944. I am going to say something about, my lord, 370. And then, my lord, about the governor's, my lord, proclamation and the presidential order. That's how, my lord. And I know I am not going to repeat. And I am conscious, my lord, because in Bhopal case, when I appeared before Justice Call, he said you have to summarize. So I am trained, my lord. I am trained in
now
that.
10 minutes, please summarize the point.
10 minutes I can, my lord. But
We have to wrap up by 4 o'clock.
my lord,
Everybody has time until 4 o'clock.
This is what happens. Somebody who is, my lord, sensible, then he is put into this difficulty.
Everybody is,
No,
Mr.
ma'am.
Parekh. We'll now wrap up. Just formulate it. Just tell us.
I'll do my best.
Just formulate it. We'll take it down. Yes.
I am going, my lord. Now, the first point is, my lord, the historical details, which is, my lord, the manifesto of 1944, which is important.
Why don't you
May I
formulate
just,
it?
my lord, I am appearing in writ petition number, lordship will just note, 1368 of 2019. And my written submissions are from page 504 in volume 1 of the submissions. Now, my lord, the formulation is like this. That, my lord, the people of Kashmir on 29th, 30th of September 1944 came together and gave themselves, my lord, a manifesto. In manifesto, they said two things we want. We want a constitution for for Kashmir, and then also an economic plan for Kashmir. Now, these two things were there. Then they went into the question of, my lord, what rights should be given to the children, what rights should be given to the women, what kind of land reform should be there. All that was part of manifesto. Now they gave it to my lord, to the Raja at that time, and then Maharaja. And Maharaja, for consideration that this is what we demand, and this is the democratic setup we want in Kashmir. Now, this particular manifesto, which, my lord, is taken as a Magna Carta, virtually, and that's what, my lord, Justice Anand says in his book on Constitution, was then accepted in the Constitution, and whatever people said ultimately in the manifesto, most of it, my lord, was included in the Constitution. This is known as, my lord, the new Kashmir, they call this manifesto. Now, the importance is this, my lord, that the sovereignty rests with the people, and they express, my lord, their sovereignty in a particular way. This is what they want. This is kind of democratic setup they want. Now, this sovereignty was, my lord, accepted when the Constituent Assembly was sitting, and was translated, my lord, ultimately into the Constitution of Jammu and Kashmir. So there are two things, my lord, which emanate from it. Number one is that the sovereignty which vests with the people, and they, my lord, expressed it, and that expression was translated ultimately, my lord, into the Constitution which they gave unto themselves. That's number one. Second is, my lord, when there is a written Constitution, then that written Constitution is supreme. Now, Lordships, my lord, noted the judgment in Article 143, that privilege case, my lord. I'll just give the citation and the para number, which says, my lord, that ultimately in a democratic country having written Constitution, it is the Constitution which is supreme and sovereign. That is, my lord, 1965, 1 SCR 414, and it is in volume 17, PDF. It starts at 337, at 357, para 40. Para 103. Note that in my submissions, because it has not come. Now, my lord, the second judgment which I just wanted
What
to
is the
draw your
proposition, Mr.
lordship's
Parekh, on
attention
this?
is, my lord, Bhumi's case, which has been cited before lordships. It is para.
So what's if you can
proposition on
conceptualize it, Mr.
The conception, my lord, that's what I'm saying. I'm saying that this, my lord, the entire idea, people said they want to have a democratic setup. And therefore they came together, gave themselves, my lord, a manifesto. Manifesto was translation of their wishes or desires, that it should be in a particular way. That, my lord, was given to Maharaja at that particular point of time, that please accept it because we want this monarchy to end, we want a democracy to come. So this expression, my lord, which was given in the manifesto, was translated ultimately, because as I said, it was a Magna Carta, and in the discussion also we find
That
they
we
have
found is in your
Lordship,
submission.
so
We look
therefore
at
the
it,
idea is that
Parekh, we look at your submission.
I know Lordship said formulated. So it's, my lord, ultimately the sovereignty which vests in the people, ultimately transferred, my lord, in the Constitution. As I said, the Constitution is supreme and sovereign. My lord, that's the idea. And I, my lord, refer to the two paragraphs. One is, my lord, in the 1965 judgment, which is para 40, and para 102 and 103. So Justice Sawant's, my lord, view in Bomai, and if your lordships permit me, I'll read only para 103 and this particular part will end. In this connection, may I give your lordship the PDF?
No, we got it, yes.
Yes. This will be PDF 171, 172 of Case Law Volume 2. 272? 271, 272. Now 102. Now 102, my lord. At 271.
Yes.
Now the lordships may skip, my lord, the earlier para, last 3-4 lines. It is true to say that democracy, people are sovereign. All powers belong primarily to people. The retention of such power by the people and the
That's true. These are well.
lordships.
we've read them.
Now, my lord, 103 is how the states are formed on the basis of linguistic, ethnic, and
That's
other
all,
things,
yes.
and that cannot be disturbed.
Yes.
Lordships were noted. That's enough, my lord, for me. Now, the only thing is, my lord, that in the book, Justice Anand, my lord, says that as far as the sovereignty is concerned and autonomy, they are, my lord, interchangeable terms, that what you call sovereignty is autonomy. Now, that is, my lord, something which is important when we say whether there is autonomy in the form of sovereignty with the people, and ultimately in the Constitution of Jammu and Kashmir. Now, my lord, with regard to the interpretation of 370, lordships have read it number of times. I just wish to point out, my lord, two things. One is, my lord, when we look at 371B and, my lord, 370D first proviso. These, my lord, two provisions, they talk about the consultation. Rest is concurrence. So my argument is, my lord, as far as the concurrence is concerned because the Constituent Assembly doesn't exist. And I must point out, my lord, how the Constituent Assembly of Jammu and Kashmir, because that has not been pointed out, how it was dissolved. There was a resolution, and pursuant to the resolution, it was dissolved. So therefore, my lord, those parts are concerned. The provisions, my lord, in terms of the 1954 presidential order, which has been issued, my lord, I know lordships are probably, if I'm repeating something, then 1954 presidential order, which is there. If you look at the 6 presidential orders which have been issued, the first one is, my lord, consultation. There are other 3 consultation. One is, my lord, CO 44, which is, my lord, under 373, where, my lord, the Constituent Assembly's prior recommendation was taken because they changed the explanation there from, my lord, Maharaja to Sadr-e Riyasat. So that is, my lord, one thing which shows that ultimately you require prior recommendation of the Constituent Assembly. The only provision is 1954, which talks about the concurrence. My submission is, my lord, that the concurrence ultimately comes to an end because the Constituent Assembly is not there. But the question arises, my lord, which your lordships may put to me, what about the presidential orders which have been issued subsequently? The only answer, my lord, which I think can be given is that all the subsequent presidential orders which have been issued are either some changes, some amendments in the 1954 presidential order. They are not, my lord, because the areas were carved where the union will legislate, and the areas, my lord, where the Jammu and Kashmir constitution will prevail. Therefore, my lord, all those things which have been issued can be justified only on this basis that these presidential orders, because 1954 presidential order was issued after, my lord, the concurrence of the Constituent Assembly or approval of the Constituent Assembly of Jammu and Kashmir. Therefore, the subsequent presidential orders which are issued were under the presumption that the Constituent Assembly's approval already exists. as far as the presidential, this is one way to look at it, because when I tried to find out, I couldn't get any answer, because if the Constituent Assembly comes to an end, naturally the entire, there is no Constituent Assembly, therefore there can't be any concurrence in that sense, which is provided, under 370. I have formulated, 370. I just read, two formulations. 370, I am reading that, provided the constitutional mechanism by which the instrument of accession was integrated into the Constitution of India. Recognized, recognized areas where the Constitution of India will operate, and by respecting will of the people, carved out the areas where the Constitution they wish to give unto themselves will prevail. Second is, 370 is temporary in the sense that it contained the principles which would govern the formation of Indian Constitution as applicable to J&K, as well as the Constitution of J&K. Once that was achieved, the aim and object of 370 was fulfilled. Seeing each other, meeting each other was converted into a relationship on mutually decided terms. It is this relationship which is permanent. This relationship could not be unilaterally altered. It is like a constitutional promise embedded in will of the people. With the dissolution of Constituent Assembly of J&K achieving its purpose of giving birth to the Constitution, the temporary provision achieved the permanent result. The other significant permanent feature being that people of J&K accepted J&K with all its territorial limits to be an integral part of India for all times to come. No, my lord. There are three documents, my lord, on the basis of which the interpretation of 370 is possible. One is, my lord, the Constituent Assembly debates in India, the Constituent Assembly debates of J&K, and the judgment in Premnath call. Now, from all these three documents, my lord, two situations emerge. One is that the Constituent Assembly will have a final say. All, my lord, the debates as well as debate in Jammu and Kashmir, and, my lord, the Premnath call judgment says so. That number one, Constituent Assembly will have a final say, and number two is relationship will be finally determined by J&K Constituent Assembly. These are the two factors which are common, my lord, in the entire thing. I just wish, my lord, because the Mr. Gopal Subramaniam had read, my lord, the debates in Jammu and Kashmir Constituent Assembly, but I just wish to draw your lordship's attention to my submissions. 504, just, my lord, look at 512.
Yes.
These are my submissions, my lord, which is in volume 1 of the submissions, starts from 504. Just kindly come to 512.
Yes.
And then, my lord, lordship may skip. This is, my lord, what Sheikh Mohammed Abdullah makes a statement on 370. The entire paragraph is that. Lordship may skip that and come to, my lord, 514. Just above para 26. The Constitution of Indian Union therefore clearly envisaged the convening of a Constituent Assembly for Jammu and Kashmir state which would be finally competent to determine ultimate position of the state in respect of the sphere of its succession, which would be incorporated as in the shape of permanent provisions in the Constitution. This briefly is the position which Constitution of India has accorded towards it. Now, this was, my lord, the same thing which we find in the debates, my lord, Gopal Swami Iyengar. He says the same thing we find, my lord, in the judgment of call. And this is what. So there was, my lord, ad item as to what should be the shape and what should govern the relationship between, my lord, Jammu and Kashmir and India. Now, my lord, 26 is, which has not been shown to your lordships, how the ultimately it was dissolved, the Constituent Assembly of Jammu and Kashmir. Now, my lord, this is the statement which was made by Mir Qasim. He said, my lord, whereas the Constituent Assembly came into being for framing the Constitution for the state, whereas the Constituent Assembly has enacted and adopted the Constitution for the state, now therefore this Assembly resolves, shall stand resolved on 26th day of January 1957, which is the date of commencement of the Constitution. Sir, I would like to make a brief submission with regard to this resolution. The resolution aims at dissolving the Constituent Assembly by passing and adopting the Constitution, which will come into force on 26 January. The Assembly has done its primary and main function, and it is but natural that it would stand dissolved. Legally, it could not have been dissolved by any authority because people elected this Assembly for a specific object. Now, the object having been achieved, it is reasonable to resolve it by way of a resolution. Hence the resolution. This Assembly is not capable of protecting the Constitution. It had only the mandate of framing and enacting the Constitution for the state and nothing more. Now we can skip the entire thing, Milord. And finally, on the next page, the last 4 or 5 lines, Mr. President, the question is whether the Constituent Assembly came into being for framing the Constitution of the state, whereas the Constituent Assembly has enacted, they adopted the Constitution. Now, therefore, this Assembly resolves, it should stand resolved on 26 January, which is the date of commencement of the Constitution. And we close the business. And then, Milord, after this cross is, Milord, the proceedings on 26th of January 1957. Mr. President, today this historic session ends. With this, the Constituent Assembly is dissolved according to the resolution passed on 17th November 1956. Clock struck 12 p.m. and Constituent Assembly was dissolved by the President according to the resolution adopted on 17th November. I thought I must draw your lordship's attention to this important part, how it was dissolved. Now, my lord, as I have read, my lord, on 370, I am not going into, my lord, the Sampath Prakash and other arguments which I am skipping because all that has been argued. Now, lordships may only look at one part. 2 parts actually. The presidential order, my lord, which was passed on in 1954, had expressly, my lord, excluded Articles 356, 357, and 360. Kindly look at, my lord, lordships have seen that, aware of that. That is volume 3, page 18. Now, these were expressly excluded. And because they were excluded, it was with the understanding that as far as there is a breakdown of constitutional machinery in Jammu and Kashmir, then ultimately it will be taken care of under the Constitution of Jammu and Kashmir. And they brought in section 92 for that particular purpose. Now, thereafter, my lord, and this was with the concurrence, which, my lord, my argument, if it is accepted, then after that, no change was possible. Because 92 had already come into operation, which took care of the entire situation. Now, 356 was brought in by virtue of CO 71 in 1965. Now, lordships will mark it. This is page 37 if you lordships want to see volume 3. Now, 357 was not adopted. 357 was not brought into. It is only 356. So, one question which arises is, we have to, my lord, question that what is the implication ultimately of 357 not being there? I hope I am clear, my lord. If your lordships want to note down the pages, I can.
Yes.
No. My lord, that 54 presidential order, just show me that. Yes, what I'm trying to, my lord, point out is this, that the Constituent Assembly of Jammu and Kashmir,
At that time,
finally,
356
when
was
the,
not-
finally the
356 was
situation.
not- 356 was not there. Subsequently, 356 has been made applicable.
No, my lord, what I'm trying to say is, I can show the debates. When 92 was inserted, section 92, what were the debates, my lord, in the Constituent Assembly of Jammu and Kashmir? What I'm trying to show is the Constituent Assembly of Jammu and Kashmir ultimately approved that 356, 357, 360 will not be there. And therefore, my lord, 92 came into being. So 92 provided for the situation because 92, equivalent of 92 doesn't exist for as far as other states are concerned. Thereafter, my lord, the changes were made, and in 1965, 356 was inserted, brought in. Said wherever constitution is mentioned, you read it as Constitution of Jammu and Kashmir. 357 was not brought in. Now, if you look, my lord, read 356, it says that you give parliament ultimately or to the president. Under 357 alone, that the orders can be passed or law can be made. Kindly look at 357, my lord. This will also have a bearing on, my lord, section 3, but I am not going to those parts. Now, 357 says, whereby a proclamation issued under clause 1 of article 356, it has been declared that power of the legislature of the state shall be exercisable by or under the authority of parliament. It shall be competent for the parliament to confer on president the power of legislature to make laws, authorize the president to delegate, subject to such conditions as he may think fit, for parliament or the president in whom such powers are vested to make laws conferring powers for imposing duties. I'll take your lordships, my lord, through the governor's proclamation 92.
Article 357 has not been made applicable.
It has not been made
And
applicable.
therefore, though Parliament can assume to itself the power of the state legislature to enact laws,
Yes,
you cannot further delegate it to the president.
correct. You cannot do that. That's not my argument. And kindly, my lord, see the proclamation which was issued on 20th of June 2018. Just look at that, my lord. That proclamation, my lord, is at volume 3, page 85. I am saying, my lord, that there is a machinery which existed to take care of the constitutional breakdown. And I am quoting again Justice Anand's book because he says, relying upon number of judgments which are given by, my lord, the Jammu and Kashmir High Court, whether it is, we can reconcile both. And the argument is, yes, we can reconcile. But the question is, ultimately 92 acts in a particular sphere and 356 acts in a different sphere altogether. You can reconcile, it can exist. But the question is, they operate in different fields. And once you exercise power under 92, and you say we are dissolving, and look at, my lord, this particular proclamation, which is, my lord, at page 85, just look at it, my lord, in 92. And I'm asking myself why 356 was not issued initially. It could have been done. Why they resorted to 92? An answer will also come, my lord. Answer is because after the proclamation, on the next date, he dissolves, my lord, the assembly by resorting to section 53 2B, which could not have been done without the aid and advice of the council of ministers. Why it was done, my lord? Because it is dissolved, and then you take over ultimately. Now, proclamation, my lord, says powers conferred by 92, enabling me on that behalf the concurrence of the. Now, one important factor I must mention. I'm so sorry, I have to hurry up, my lord, otherwise necessary for me to show, but because lordships are aware, I'm going on that basis. Section 92 says, my lord, concurrence of the president. So naturally, when this proclamation was issued, there was proclamation, it says so. There is a proclamation of President of India. Now he gives, my lord, the concurrence to the proclamation which was issued, the president. And after that, my lord, certain provisions are suspended. He says any reference to state constitution or acts or made by the legislature shall be construed as including reference or acts made by me. That is on page, my lord, para 5. In exercise of powers of legislature of the state under the proclamation made under such and such. So assumes, my lord, on that date itself, the powers to make the laws. Now, my lord, look at this one and 357. How you reconcile both the things. And next day, my lord, he says power vested upon me under 92(1), exercise of powers under 53(2)(b) of the Constitution, Jammu, I hereby dissolve the Legislative Assembly. Now, 350, section 53(2)(b). If we read, my lord, section, I think 35, that this can be done. 92 you can exercise without the aid and advice of the Council of Ministers, but 53 you cannot do, which is necessary. So he does, my lord, a thing which is absolutely unconstitutional act. It was impermissible to do it. My argument here is, if your lordships, my lord, I can give certain, there's a discussion by Justice Anand in his book about how these two provisions can work in Kashmir. That is volume 17, PDF, my lord, at 143, 144. What is it? So, my lord, my submission is, in this situation, it was not permissible for the president, my lord, to invoke the powers under 356 because under 92, and 92 is something which was approved ultimately by the Constitution of India and also the Constitution of Jammu and Kashmir. It's a malafide, excess of power, and a fraud, which, my lord, I don't want to go into the judgments. Now, my lord, my probably last, I must say, argument is with regard to CO 272 and 273. Just kindly have a look at, and the argument will be very brief. Kindly look at, my lord, 272 at page, I think, PDF 101. Lordship had put a question to Mr. Sibal. This is 5th of August 2019. And 6th, my lord, is the final order which has been issued, CO 273. I must say, my lord, before I go to 272, is that 273 assumes, my lord, the fact that the prior recommendation of Constituent Assembly is necessary. If we understand that way, my lord, then kindly look at it. It means if you want to make any change in 370 as such, which we draw, my lord, from CO 44, which I pointed out, where you change the explanation. That's the only thing, my lord, which the Constituent Assembly approved. Now, here, my lord, what they do is that through the interpretation clause provision, they, my lord, indirectly change 370 itself. Kindly look at, my lord, this one. To 367 shall be added the following clauses. Lordships may skip A. A says construed as references to such and such. B is references to person for the time being recognized by President, recommendation of Assembly, Sadr Riyasat, acting on advice of Council of Minister of State for the time being in office, shall be construed as references to Jammu and Kashmir. Now, exactly the same words which are used in the explanation. So they are changing, my lord, the explanation without the prior recommendation of Constituent Assembly. And look at, my lord, below that. In proviso D, 3 of 370, expression Constituent Assembly of State 2 shall be read as Legislative Assembly of the State. Now, my lord, I ask myself that how this is possible that you can change 370 as such by virtue of the interpretation when you recognize in the very next order which was issued that Constituent Assembly's prior recommendation is necessary. So this interpretation, my lordships are asked, why this interpretation? Without this interpretation also something was possible. This interpretation was resorted to because they wanted to show the exercise ultimately done by them by CO 273 is something which is constitutional in nature. That is to say that they have done this thing after prior recommendation of the Constituent Assembly. So how they may not achieved it, they changed 370 to the interpretation clause. Absolutely, my lord, unconstitutional act. And after doing this, I hope I am clear, my lord. After doing this, then, my lord, the final order is given. What it says, CO 273. In exercise of powers conferred by clause 3 of 370, read with clause 1 of 370 of the Constitution, the President, on recommendation of Parliament. So, my lord, the recommendation of the Constituent Assembly after that was substituted by recommendation of Parliament. Is pleased to declare as from the such and such all clauses of the 370 shall cease to operate. So what they do is they know without Constituent Assembly they cannot do. Constituent Assembly is not there. They bring in through the interpretation indirectly. And my submission is what you cannot do directly, you cannot do indirectly. That's again a fraud on the Constitution. Lordships have followed, my lord.
This argument has been raised.
It was, I am so sorry, because I think I was attending all the, in this, because Lordships have put a question to Mr. Sibal, what's the meaning of this interpretation clause? Why they resorted to interpretation? They resorted to interpretation because they could not have done directly with 370. Therefore, they resorted to, and after making change, came out, my lord, with this one, on the recommendation of Parliament. Now, other question, which is a prior recommendation. According to 373, it is prior recommendation of Constituent Assembly. It has to be prior recommendation. Now, kindly look at on 5th of August, this notification is issued. How, my lord, next day, a prior recommendation of Parliament was sought. On the face of it, my lord, it looks obvious that this is something, my lord, which is not permissible. The entire exercise, my lord, shows that it is malafide in nature. So therefore, my lord, this goes, 272 goes, the other, my lord, proclamations which are issued, they also go.
Thank you, Mr. Parikh. Thank you.
My lord, it becomes very difficult sometimes because I know, because you read a lot, chip by chip, my lord, things are removed. Few chips remain, my lord, then you have to sustain yourself on those chips. So probably I do not have done whatever.
Thank you, Mr. Parikh. Mr. Sen.
Not more than 7-8 minutes.
Yes.
Fast as possible. Now, just 3 points I want to highlight. Proposition being a more restrictive and strict approach in interpreting Article 370 for 3 reasons. I'm taking the broader view because the nuts and bolts have been gone into. The first reason is historical. The second is jurisprudential. And the third is in terms of the constitutional ethos. The historical part, my lord, which I'd like to emphasize for a more restricted and strict interpretation is that the region consisted of a Muslim majority. And the population, my lords, had a choice between either going into Pakistan or into India, either being a majority in Pakistan or choosing to take a minority status in India. My lords, it chose the latter. And my lords, although the historical part has been dealt with about the signing of the instrument of accession, just a few pages I'll highlight to show how it was Sheikh Abdullah who represented and who had a hold over the population at that time, who was responsible for this transition to India. And therefore, my lords, one of the important points which I'd like to make is that if there is a choice, a conscious choice made to remain a minority in a region in the backdrop of the horrific violence of partition, my lords, when there's a constitutional promise in the nature of Article 370, it should be strictly construed. That's my first point. And my lords, in regard to that, my lords, may I just point out 2-3 pages, VP Menon's book on the integration of the nation state. I'll just point out the pages so that I don't take time. My lords, page at volume 15, PDF page 1258, where it just mentions that Sheikh Abdullah rose to power to fight for the rights of the Muslim community. By 1939, the body had shed its communal complexion and changed its name to National Conference. He had a considerable hold over the people of the state. That is B.P. Menon's book at page 1258. Then, my lords, may see page 1259 PDF. The Maharaja was assured by Lord Mountbatten that if he acceded to Pakistan, India would not take it amiss, and that it had a firm assurance of this from Sardar Patel himself. Lord Mountbatten went on to say that in view of the composition of the population, it was important to ascertain the wishes of the people. This is PDF page 1259, volume 15. The situation for the Maharaja was not easy. This is again Menon pointing out. If he acceded to Pakistan, the non-Muslims of Jammu and Ladakh, as well as considerable section of Muslims led by National Conference, would have resented such an action. That is page 1259, PDF page 1259, volume 15. The government of India had no territorial ambition in Kashmir. If the raid by the tribes had not taken place, government of India would have left Kashmir alone. That is at page 1271, PDF, volume 15. The tribal invasion was not a spontaneous affair engineered by Pakistan. That is at page 1271, volume 15. The accession was legally made by the Maharaja of Kashmir, and this is important. And the step was taken with the advice of Sheikh Abdullah. That is PDF page 61, volume 20. This is A.G. Noorani's book. This is not, up to now I was stating Mr. Menon's book. This is A.G. Noorani. And then, my lords, may see on 27/10/1947, in reply to the request for accession by the Maharaja, the Governor General of India, Mountbatten, clearly stated that the issue of accession should be decided in accordance with the wishes of the people as soon as law and order had been restored in Kashmir. This is PDF page 59, volume 20. In the context of these historical facts, both Nehru and Sardar Patel were of the clear view that Jammu and Kashmir should decide their own consequences. See letter of Jawaharlal Nehru dated 18th of March, 1949, PDF page 67, volume 20. This is again A.G. Noorani's book. It is in this context, my lord, that 370 emerges. So, my lords, my first submission is this, in this context, that when there is a conscious choice made in this manner, my lords, all the more reason why it should be taken strictly. And in this context, may I just point out S.R. Bommai at page 218, PDF page 218, volume 2, which says that federalism is not seen merely as a matter of administrative convenience, but one of the principal outcomes of our own historical process and a recognition of ground reality. And, my lord, this leads to what is called asymmetric federalism, my lords, which has been extensively dealt with by my lords in the NCT Judgment 2. It is also, my lords, in fact, one of the first persons who coined the term asymmetric federalism in the Indian context was Professor Balbir Arora from Sorbonne, and he was also the professor for political science in JNU. And his book, my lord, which is at page 242 to 243, PDF page, volume 17 of the document compilation, where he talks about the nature of asymmetric federalism, which was there, which is to take into account different regional aspirations, and it has a remarkable degree of flexibility and pragmatism. It is a calibrated institutional response to the diversity of constitutional unit permeating both de facto and de jure variation. My lord, thereafter, my lords, may I just point out the above fact that it is an anti-majoritarian or a protection against majoritarian that asymmetric federalism provides. And in that context, my lords, our constitution is also a anti-majoritarian in many ways, my lords. There are lots of judgments which have dealt with it. I put it at E.3 of my written statement at page 500. That is E.3 of my written statement. Then, my lords, Keshavanand Bharti case at para 208, PDF page 151, volume 15, where I point out that where it is emphasized that in case there is a it quotes, my lord, the case, and I'll just quote it. I may mention that the Judicial Committee, while interpreting British North America Act 1867, had also kept in mind the preservation of the rights of minorities. For they say in the regulation and control of aeronautics in Canada, The British North America Act embodies a compromise under which the original provinces agreed to federate. It is important to keep in mind that the preservation of the rights of minorities was the conditions on which such minorities entered into the federation and the foundation upon which the whole structure was subsequently erected. The process of interpretation as the years go on ought not to be allowed to dim or whittle down the provisions of the original contract upon which the federation was founded, nor is it legitimate that any judicial construction should impose a new and different contract. This is echoed in Jindal Steel case at 2017-12 SCC 1, that is PDF page 219 to 220, where it is very clearly pointed out, again, it reiterates Keshavnan Bharti, that the original terms should not be whittled down. And so, my lords, the argument that so-called hollowing out of the Article 370 through various orders which have taken place. Already Mr. Nafe has argued that there was no hollowing out, the core remained. But assume that there was a hollowing out which takes place. It is a political act. And my lords, has been very clear in this entire proceedings that we are interpreting the Constitution. So if because of a political act, there is a so-called hollowing out, which is without prejudice to that argument, I do not accept that it is. But if there is such is the case, even then that should not affect the interpretation of the provisions of Article 370. Then, my lords, Podwal case again highlights the aspect of asymmetric federalism, which I will not go into. My lords, the second point, briefly, what are the limits, my lords, if you're looking at the broad approach, what are the limits by which we will determine what are the limits of a constitutionally vested power? And my lords, the answer is the analogy of Mill's famous thing on liberty, that your liberty ends where the other man's nose begins. So the moment there is a fundamental constitutional principle which is there, which is getting affected, the limit must be there. And my lords, in that context, the NCT judgment case, there are 2 pages I'll just point out, PDF page 92 at para 108 volume 5 and PDF page 35 at para 40 volume 14. My lords, also there is the Miller case, that is at PDF page 324 of volume 5, recent Miller case in the UK, in the context of proroguing of the House, where again this concept is put forward. So it's an international constitutional concept which is also equally applicable here. It has been reiterated by various judgments in India. My lords, I would also urge that if we are talking about minority rights, if we are talking about anti-majoritarian or protection against majoritarian, well, there is the LGBTQ plus judgments, etc., which are coming. There is a evolution which is taking place. With respect, my lords, this kind, if one were to do away with this thing which involves historically a religious minority, not that they are necessarily expecting, if that is there, my lords, it will be a regressive step. And my lords, in line with what is happening, in which the evolution is taking place, more and more inclusiveness is there, it should not be there. I'd like to finally end, my lords, I won't take more time. I'd like to end by pointing out 1 or 2 quick points. One is, my lords, in our rejoinder at page 88, the Niti Aayog report is there. Now, my lords, there is no material which has been brought on why 356 was imposed. My lords, that has always all been argued. But the material of the government which is already there on record, it says in peace, security, effective governance based on rule of law and upholding principles of equality, Jammu and Kashmir rises above a number of states. And my lord, that I've put at page 88 at volume 13 of the Niti Aayog report, page 282 of volume 13 at page 286 and page 285. This is prior to abrogation. So my lords, this further kind of deepens the mystery. And of course, there are statements made by ex-constitutional authorities, not of much relevance now that he's not holding a constitutional post, but how it was exercised. But when this was the case, if Kashmir was a leader, it's used as a leader in these areas, where was the need for a 356? Well, let's finally one last anomaly which my learned friend had also pointed out, and that is, I'll just point out that in volume 3. Sorry, just a minute, just on the reorganization. I'm sorry. Yes. My lord, we come to section 57. My lord, it's the botched up kind of situation which is arising now with this. Of course, the Reorganization Act is consequential, I understand, but still, my lord, I may just point this out. 57 at PDF page 126, volume 3. My lord, it says, notwithstanding anything to the contrary, contained in any law, document, judgment, ordinance, rule, regulation, or notification on and from the appointed date, the Legislative Council of the existing state of Jammu and Kashmir shall stand abolished. On abolition of Legislative Council, every member shall cease to be, etc. So it abolishes the Legislative Council. Now, my lords, what is peculiar is, just before this, the CO 272 is passed. CO 272 applies all the provisions of the Constitution. When you're talking about abolishing the Legislative Council, then it has to be as per section 169 of the Constitution of India, which is already stands applied on pursuant to CO 272. Once that is applied, then my lord, what happens? It can't be done away by way of this act. So we've already challenged the validity of this act, but my lord, this is like a Trishanku Legislative Council, which has not been abolished by any proper procedure which is prescribed by law. So my lord, that was the point, and there was one more point. 73, my lords, is that, my lords, clause which has come even by way of amendment in the context of the Delhi government also, that if the president on receipt of a lieutenant governor, my lords, the same powers as 356, but no time limit provided. I'm very grateful, my lords, and I'm extremely grateful that my lords had this the technology which enabled us even many times, even while you were not present in court, we could keep in touch with
Thank you.
deeply obliged.
Yes, Mr. Ramakrishnan.
One of the major political parties, and was heading the government at the time of governor's rule. And I have held office. I've formed the government twice before. I was a single major party, and I am therefore, I would venture to suggest, much more representative of legislative will than that ersatz and duplicitous reference in CO 272 to the Legislative Assembly. I also represent writ petitioners in writ petition 1099, where Mr. Ramachandran was appearing, petitioners 3, 4, and 5. As far as I'm concerned, I appear for PDP. I don't
Who are
know
you?
what this is.
Who are you?
Who are you?
This writ petition 1099 was initially filed by 6 people. Then 2 of them withdrew, Dr. Shah Faisal, and then.
I don't know what he's talking about.
Then the writ petitioner number 1, who is Mr. Javed Bhatt. Javed Bhatt, when he engaged my learned friend, then the understanding of senior counsel Raja Ramachandran would be arguing the matter. When he came to know that he has withdrawn from the matter, then he contacted a senior lawyer from Kashmir, Mr. Muzaffar Hussain Beg, who in fact.
I didn't know anything of this. I'm sorry. Let me represent PDP, the impleadment application. My lords will hear him whenever it's done.
We are not PDP.
Yes, I'm arguing for PDP now. My lords will hear me.
That's an intervener application, but the mandate petition, Farooq Bhatt is the petitioner number 1. When he engaged them, then the understanding was that Mr. Raja Ramachandran would be arguing the matter. When he withdrew from the case, then Javed Bhatt petitioner number 1, he approached Mr. Muzaffar Hussain Beg. So we have filed the Muqaddimah that perhaps not has been placed on the board because of some timeline issues.
May I clarify?
That petitioner number 1 in writ petition number 1099, Mr. Muzaffar Hussain Beg would be arguing, of course, with the permission of my lords.
See, ordinarily there's no difficulty, but normally for all of the entire group of petitioners in a petition, you presume that they are sailing together. Therefore, one lawyer would appear for all the petitioners. For different respondents, different lawyers can appear. But for people who join together in a petition,
May I?
if there is some conflict within the petitioner, somebody has to get transposed or file another proceeding.
That conflict arose because of the wrath of Mr. Raja Ramachandran only.
May I make a clarification, Your Lordship?
Just for factual clarity, writ petition 1099 was filed by how many people?
By may I?
Just 1 second. He's in charge. 1 second. Yeah.
I instructed in the matter, Your Lordship. There were initially 7 people.
Yeah.
Of which Dr. Shah Faisal and Ms. Shaila Rashid subsequently withdrawn. Mr. Ramchandran, in fact, argued their applications for withdrawal, and this was allowed by this court.
So we're left with 5.
There were 5. There was one Mr. Javed Ahmed Butt, his was petitioner number one, who became the petitioner number one after Dr. Shah Faisal's withdrawal. So last evening, I received a request saying that there has to be a way in which we had another arguing counsel with the team. And this was because this was contrary to the express orders of the court, where it had said that all the petitioner's arguments had to be wrapped up today, and that a certain list was had. So and therefore I deemed it unreasonable to accede to that request at that time, and I had indicated that they are free to pursue their remedies, whatever they have, and they had therefore requested no objection. On which I had a separate, very detailed release covenants that I had in fact received from the petitioner, where in the detailed release covenants he had covenanted that these hearings would not be interrupted, and after the hearing plan is over, if anything, with the permission of the court, he may take that is because as also the nodal counsel, we owe duty to the court that the.
Just 1 second, 1 second. Jadara mic band karo.
I don't want to appear for anybody in this writ petition. I will just appear for PDP. Yes, I don't want to appear for him. Uncouth to interrupt like.
In the petition which you are arguing, it is 1099. You are the first counsel to argue, right?
Yes, because Mr. Ramachandran requested me.
Right. In the last 3 weeks, you are the first person who is arguing this matter.
Correct. Until yesterday, I thought I was arguing for all the petitioners. But I'm happy to please keep quiet. I'm arguing for PDP definitely.
Yes.
And let me argue for them. If my friend who he represents in that petition, I don't.
Now, Mr. Counsel, what you are suggesting is that Mr. Muzaffar Hussain Beg will appear for Mr. Javed Butt.
Yes, ma'am.
Now, you see, there's only one difficulty. See, we want to be fair. We don't want to shut out any voice. It's our duty to give a fair hearing to all perspectives. At the same time, you're also conscious as a member of the bar that in a petition, when a group of petitioners have come together, one lawyer appears for all the petitioners. There may be a little conflict or diverging interest between respondents, and therefore respondents are entitled to have separate representation. But at the same time, we are more than willing to hear Mr. Beg's perspective. The way to do it is then Mr. Javed Butt will perhaps have to withdraw from that petition 1099, and we'll permit Mr. Beg to make a brief representation as an intervener. We can do that. Ultimately, it's a question of yours of being heard by the Supreme Court, isn't it?
So of that. And she has very gracious.
So, Ms.
She has very gracious
Ramkrishnan,
that she would be representing PDP only.
Ms. Ramkrishnan, now the remaining 5 petitioners in 1099, who are those 5 petitioners? Is PDP party in that? Just 1 second.
PDP is an impleadment application. She is an impleader. Because she was in jail. She was in imprisonment when all these petitions were.
Her application is for impleadment.
Yes.
As a petitioner.
Yes.
But the others have to agree to her impleadment.
They have agreed. They have no objection.
Not impleadment, not for petition, as petitioner, my lord. She wants to be impleaded.
Correct.
Who represents the other four? One of them, this is a new development, but
Just one second, one second. Who's for the other four now? Or the other five? Because actually there are five now left.
Shah Faisal withdrew.
And likewise, Ms. Sheila Afridi withdrew. Now who's appearing for the remaining five?
Was stated to appear now until this.
Ms. Ramkrishnan, are you appearing, forget Javed Bhatt's case for a moment. We'll say the remaining four. Apart from appearing for the PDP, are you representing the four as well?
I was given to understand that until this minute.
But even at this minute, he is
I
representing.
represent it. If
So we take it apart from the impleader, intervener, which is the PDP, you are appearing for the remaining four. And you have instructions to appear for them by the advocate on record. All right. Now, insofar as Mr. Javed Bhatt is concerned, we will, what we'll do is we'll complete the submissions of Ms. Nitya Ramkrishnan. Rest assured that we will give a, let's see how things progress. All right. We got the point now. Yes. Yes, Mr. Ramkrishnan.
I'll try and speak in bullet
But then
point.
only one thing. Do we take it that you, Mr. Javed Bhatt, seeks to withdraw from this petition so as to allow him a separate intervention?
No, no, he is not withdrawing as a petitioner.
But then if he is not withdrawing as a petitioner, we are trying to create some space for you. If he is not withdrawing as a petitioner, then the advocate on record will appear for him. How can you have a different counsel appearing?
Because he has obtained an NOC, and the reason as a.
when did you obtain
When did you obtain the NOC?
Very respectfully, I submit.
When did you obtain a NOC? Please tell us.
Yes, my lord. Then
You can't do that.
The matter on the last date of hearing, you obtain a NOC. Then you say, now I want to appear for that one individual petitioner. He will continue to be the petitioner, while four others or five others are represented by another counsel. Because background or no background, we are not.
This we will not
background
permit.
much earlier.
In any case, one thing is very clear, even in a normal civil appeal, we will not permit people to withdraw in the course of a submission. And not when a matter has gone on for 3 weeks. This we will not permit.
my submission.
We will, please understand the position in law. We will go strictly by the position in law. We will give you an opportunity, should Javed Bhatt not wish to continue any further with Ms. Ramkrishnan's petition, no difficulty, we will permit him to delink himself and we will give him a separate hearing. But he cannot be a part of that petition and say there'll be two lawyers arguing for them, because there may be a conflict of arguments in that, which is not permissible in a petition. We saw that, for instance, Mr. Dwivedi adopted a different line, but he couldn't do it because he was in a different petition.
And as I submitted, I beg to reiterate, Lord, the situation arose only when Mr. Javed Bhatt came to know that Mr. Raja Ramachandran is not arguing the matter.
But that was so for the last 3 weeks.
Yes.
Everybody knew that he's not going to be appearing for the last 3 weeks. He didn't appear.
Was not appearing in the list.
Well, on the first hearing 2 years ago, he opened the argument. 3 of us were party to the bench. He is the one who had opened the argument. Now it was said thereafter that for whatever reason, Mr. Sibbal now started it. He was not available. Now suddenly in the last state of hearing, at the last nth minute, you say, not only at the nth minute you interrupt and say, well, I want to sail in some other boat.
She's running for submission.
All right, we'll cut through all this. Above all, we are absolutely sure in our mind that we want to give an opportunity to different perspectives, because we have to be duly apprised on all sides, different perspectives, different points of view. As we said, even within the petitioners, there were different shades of constitutional argument. We'll not shut anybody out. We will hear, but let's follow the correct procedure in law. Let's not set down procedures which are wrong. Mr. Attorney General, we'd like your assistance on this. Forget now that you are. Will that be a proper procedure, Mr. Attorney? Yes, Mr. Ramkut.
All this happened to me. Vijay, if I may just, I don't know who to.
I gave only purpose of thinking of nothing.
Mr. Beg, please rest assured, we'll hear you. No difficulty at all. Please be in the court, Mr. Beg. Mr. Beg, you can be in the court. You don't have to leave. You can be in the court now. We'll hear you after. You can be in the court. Yes. Please ask one of the juniors to give a chair to Mr. Beg so that he can sit down. Yes. Yes, Ms. Ramkrishnan.
But I'll try to make my arguments in bullet points, so I'm quick. The first point I wish to make is that integration is neither a linear concept nor a quantitative concept. There is a spoken and unspoken assumption that Article 370 is temporary in anticipation of some greater
It's
integration,
neither a linear concept.
nor a quantitative one. My friends on the other side.
Yes. Looks like we'll go on to the lunch. Since we are 6 or 7 minutes short of 4 o'clock, and there's an event at the bar in the evening, otherwise we could have continued till 5:30. You are going to argue on Article 356.
No, I was going to argue on integration, shared sovereignty, and the political context in which this happened, because it's directly relevant to our judging it.
Let me suggest one thing. Can you put down what you really have to so that it brings clarity to us? We are also at the end of the argument, so there's a tendency to be just jaded by the length of submissions. If you can put everything down on one page, just formulate exactly what you're, and then, for every submission, you can cover yourself in about 2 minutes so that we have some clarity on what you're arguing.
That's what I have in mind, but would
fair
you
enough.
want it in writing?
Just a page or so. Just give us a page. No, give it to us tomorrow morning. A page.
Tomorrow morning.
Now, Dr. Guruswamy, on delimitation, we are not going to hear this because delimitation is not an issue at all which arises here.
It was challenged and it is confirmed by this honorable court.
Justice Paul's judgment, yes.
My Lord Justice calls it.
On internal sovereignty.
Sovereignty, not repeating any argument.
And not on delimitation.
That's
Likewise. So what we'll do is, we'll likewise request you to formulate your points on just a page on internal sovereignty, right? Then Mr. Manish Tiwari, what would you be arguing? You are going to Northeast, how can we hear it in this matter?
Follow to abrogate 370 and bring about the reorganization of Jammu and Kashmir and its implications quay the Northeast because 370 is succeeded by 371 and there are asymmetric guarantees which were given and those guarantees have implications on national security because the Constitution, while being a legal political document, also performs a very important national security function in terms of integrating the periphery and the revenue.
So let us formulate it like this. What you want to really argue is that the impact of the argument which would be propounded by the other side on other similar provisions of the Constitution.
What Your Lordship,
similar provision.
respectfully, what I want to submit is that there is already a process which has been adopted by Parliament in terms of abrogating 370. So therefore, there's a precedent in place. And that precedent has implications qua the other guarantees in the Constitution, especially with regard to the northeastern state. So those are the implications which I would like to point out, and I would not take more than 15 minutes of your time. And I assure you, it would not be a waste.
Likewise, what we would suggest is if you can put it down on this evening on a one page.
I would do that.
Then we'll have clarity on exactly what the focus is. All right. Then what about Ms. Farasat?
Malice in law, it's a point by anyone. And in fact, one proposition is in our has been asking, clarifying, and a quick point on federalism.
All right, Ms. Farasat, you can also reduce what you have to say on a piece of paper, on a page.
Yes, I'll do that.
And where's the nodal counsel? By the evening, please put together all this and give soft copies to the court master, what we are now proposing to do. Then what about Mr. Irfan Lone?
Yes, Lordship.
You're for the intervener?
Very briefly, I will not.
You're on federalism.
Federalism, rule of law, and
Fair enough.
and democracy.
Fair enough.
Because
Just,
that is the soul of the constitution.
absolutely, no difficulty.
This was not followed in
Just the modalities, put it down on a sheet of paper so that we'll have clarity on what you're arguing, because now we have had arguments before you, so we'll know exactly what is it that is different that you are arguing.
This lordship, we are given only 10 minutes, so within.
Dr. Z.A. Bhatt. Now, malice in law is being argued by Varisha Farasat also.
Searcher in 370, there is something very important things which have been left out.
All right, one page, you can please put it down on paper on a page this evening and give it to the nodal council. We'll hear you for 5 minutes or so. And finally, Mr. Gopal Shankarnarayan.
Tell your lordships candidly.
Now, what we'll do is this. We'll come back to you.
Yes.
Mr. Ramakrishnan, we'll give you 10 minutes tomorrow to formulate. Dr. Guruswamy will give you exactly 10 minutes to formulate tomorrow. Mr. Tiwari will give you 10 minutes too, once you put it down on paper. If you can all circulate it to the court master by 8 o'clock this evening, we'll all have an opportunity to read what you have written by early morning tomorrow. And then everybody else, after Mr. Tiwari, Varisha Farasat, Irfan Lone, and Z.A. Bhatt, we'll give you 5 minutes each to conclude your submissions once you put it down on paper. Then the cutoff is lunch.
Minutes, lordship. Lordship,
Mr. Shankarnarayan, after they have all concluded, we'll give you the wrap-up word on the.
Lordship, the earlier list indicates the 10 minutes. So.
You know, time is over already this evening. We have already permitted. So Gopal, be ready tomorrow. We will hear you, Mr. Beg, if you can give us likewise, say by 8 o'clock today, a note not exceeding 2 pages on what your line of submissions is.